Ladies and gentlemen, welcome back to the Taiwan Internet Governance Forum. It's now time for the final session of the day, panel discussion number 6. In this session, we're going to focus on Indo-Pacific AI regulatory trends. Please join me in welcoming the moderator for the session, Mr. Seth Hayes, Managing Director of APAC Gates. Joining us on site, please let me introduce Ms. Tseng Ken-Ying, partner of Lee & Lee, attorneys at law. Next, Mr. Toshiaki Tateishi of JAIPA. And Derek Baladjay, Research Manager of Amador Research Services. And joining us virtually, we have 2 panelists who are contributing to our discussion from afar. Ms. Huria, Managing Partner of Kahui Legal. And Mr. Ragland, Senior Director, Policy APAC of Business Software Alliances. Lanelle and Jared, can you hear us? Okay, great. I'll now hand the floor to the moderator, Mr. Hayes.
Good afternoon, esteemed panelists, distinguished guests, and everyone. It's an honor to moderate today's discussion on Indo-Pacific AI regulatory trends. It's a topic that's, of course, both timely and urgent. My name is Seth Hayes, Managing Director of APAC Gates, where I help international associations and nonprofits working on innovation policy to grow in the Asia-Pacific region. So, of course, AI regulations, this is a moving target. By the end of today's discussion, things will have completely changed, I'm sure, somewhere in Asia. But it's very important for us to pay attention to what's going on in this space. Just recently at the United Nations General Assembly, last week, Asian countries voiced their concerns and perspectives on AI governance and regulation. So the focuses ranged from the responsible use of AI and its equitable access to its benefits, all the way to the impact on military security and the need for global governance frameworks. So, of course, these discussions here underscore the complexity of AI regulations, especially in the Indo-Pacific region, which oftentimes finds itself overshadowed by the spotlight that's on the EU when it comes to their AI regulations, the US and its posture, as well as China. So as we delve into today's agenda, let's keep in mind these shared areas of concerns across Asia. We also need to focus on very important definitional questions. What do we mean when we talk about artificial intelligence regulations? What existing laws and other legal issue areas out there are adapted to address some of these unique challenges, whether it's from intellectual property to privacy, as we've heard, to human rights? So I really look forward to hearing a robust and enlightening discussion from our panelists. It will be a journey around the Indo-Pacific region. We'll start on the shores here in Taiwan, move to our neighbors in Japan and the Philippines, as well as further afield in Southeast Asia and Oceania. And we've got an absolutely stellar panel assembled today. We will first have discussions about individual jurisdictions and/or from individual issue areas for about 10 minutes. So I'll help keep time for our panelists so that we can ensure there's good discussion for the end. So let's begin right away. Here on the shores of Taiwan, we've got Ken-Ying Tseng. Ms. Tseng, of course, is our first panelist, and we're very honored to have her here. She's Managing Director of the Taiwan Internet Governance Forum, which is hosting us today, and she's been engaged in matters and activities regarding ICANN, internet governance, data protection, tech laws for over 20 years. And of course, she's a partner at Lee & Lee Attorneys at Law. So Ken-Ying, would love to hear a little bit about what's happening here in Taiwan in this space. Thank you.
Well, thank you, wonderful host. For the introduction. I'm trying to do a brief summary of what's going on in Taiwan on the regulatory side. This year has been an amazing year. Many big shot AI figures came to Taiwan. In June, we see Jason Huang from NVIDIA. He delivered a speech at National Taiwan University. And then we have Lisa Su from AMD also received an honorable degree from Yangming Jiaoda. And then my law professor from Harvard Law School, Lawrence Lessig, was here in September, delivered his very first speech on AI and the democracy in Taiwan. And then we have this huge AI summit with all these masters, including Sam Altman. They are coming to Taiwan to share their vision and thoughts on AI. Let's see, we can listen to some of this.
Run, don't walk.
Mr. Huang said, run, don't walk. The remaining part is a little bit frightening. He said, run, don't walk. You are either running for food or running from being food. So that's sort of describe how competitive in the AI industry and the new digital environment. And that's Lawrence Lessig.
Consider how we might regulate them to avoid the equivalent of this annihilating consequence.
So Professor Lessig was worried that if we don't regulate AI, then we will have the Oppenheimer moment. So that's his thought and take for and advice for Taiwan. Then that's the Sam Altman.
Regulation has been not a pure good, but it's been good in a lot of ways.
So Sam, I think he can represent the industry. What he said in Taiwan is that regulation is good. He thinks it's better to have regulation so that he doesn't need to have a second thought on the safety of all the products, so which is a positive position on AI regulation. So what has Taiwan been doing for regulation of AI? So earlier this year, we saw that news saying that Cabinet, they want to propose a new bill on AI and also to amend our Data Protection Act. So a lot of effort have been spent on that regard. We have so many meetings on whether we need to revise our Privacy Act. And also they are talking about whether we need to have a basic AI law. And we have the AI Action Plan 2.0. And in the plan, we have said that we will spend more than $8.16 billion on AI development. And also in that plan, we said that we are going to revise many statutes and acts to regulate AI. And in June, the news said that Taiwan want to implement AI regulation as early as end of 2023, and which is referred to our Basic AI Act. And then in early July, that's a selfie taken by Taoyuan City Mayor, also promoting that we are going to have a basic AI law. But then just at the end of July, the head of National Science and Technology Council said that we are going to hold off on basic AI law because it may hinder innovation. So we saw a very dramatic change. Just in June, we want to accelerate to have an AI law, but then suddenly in July, the high-level government official determined that we need to hold off drafting of AI law. But in the meantime, because AI still exists, people are using them. I guess the regulator also sensed the need of sort of guidance or directive on that. So for financial industry, because they have been adopting AI technology for quite some time, so the Financial Supervisory Commission, they have issued a AI directory for the financial industry and open for public comment. In that, they sort of propose the 6 principles about how to use AI. Among them, they talk about accountability. They also talk about protection of privacy, as well as sustainable development. And then just recently, the cabinet signed off our public sector AI guidelines. It's about how our government agency should use generative AI technology. Inside the guideline, it's just actually less than 1 page of A4 paper. There are just a few guidelines, and among them, they talk about confidentiality. If there is anything that is national confidentiality, then they shouldn't use AI to process the information. And also, they ask the government official to respect privacy and also to be responsible for reviewing all the results generated by AI. It's a very short guideline, but this guideline has been sort of taken effect among government agencies. And then we have this news about the judicial yuan will take AI technology to do court rulings to facilitate judges' job. For certain types of case, one is traffic case, the other one is the phone fraud case. Only specific 2 kinds of case, and only at some tax run courts, they will adopt AI technology to generate the judge's ruling. But the judicial yuan emphasized that they will not use AI to make judgment. The AI technology is only to form the draft of the decision, because the 2 cases that I cited, there are violence case every day and eat up the workload of judge. So they want to sort of release their workload for other cases. But of course, we lawyer raise objection. So because we don't know how the ruling will be drafted and based on what sources and what data has been fed to the AI training system. So recently, some of our members from Bar Association raised objection to the government, saying that before that, you need to tell us more to be more transparent. So what to expect from Taiwan? We are going to have an independent Personal Data Protection Commission in the future. It's still in the preparation stage. But once we have this agency, the agency will amend our Personal Data Protection Act, and they will sort of deal with all the issues that we are facing now, including those we have been discussing in the previous 2 workshops. And for copyright, our IPO sort of hold the same position as the US one. So right now, AI will not be able to be a copyright holder. And also, if you use AI to generate your work, you need to be cautious, because you may be infringing someone else's copyright. And I think the government is still to enact the AI basic law. We just don't know when. Maybe after the big election, they will do so. So what we can expect is that there will be more AI ethical rules, code of conduct, or directive in between before we have the actual AI basic law. So the existing document we have saw issued by the cabinet or by the Financial Supervisory Commission, I think those will be the basic for the other agency to follow to issue more AI guidance or directive. So that's what about going on in Taiwan. Thank you.
Thank you very much, Ken-Ying. It obviously sounds like here in Taiwan, not only is it a moving target, it sounds like it's a tennis ball going back and forth in terms of the government's direction on wanting to legislate or not. But then it manifests not necessarily in an overall general law, but in very particular industries by individual regulators So it's something for us all to watch. Let's go to Taiwan's neighbor, Japan. Today we have Toshiaki Tateishi, who is the vice chair of the Japan Internet Providers Association. So we're pleased to have this esteemed expert here with many years of experience to share with us what is happening in Japan in this regard. Thank you.
Thank you very much. I'm Toshi Tateishi from Japan. Now I'm vice chair of the Internet ISP Providers Association and also the College of Graduate Studies of Informatics. I'm a professor too. So, could you change? Thank you. So, oh, I'm sorry a little bit. The figures. So in Japan, so the ministry, especially the Ministry of Internal Affairs and Communications, dealing with AI matters maybe 7 years or sometimes 8 or almost 10 years. So the first of 2016 in the G7, it was a very 7 years ago. Also, MRC raised a need for international discussion on AI. Just they raise up the discussion issues. Then after that, like this figure, OECD, Digital Economy Policy Committees make AIGO by the AI expert group. Then probably all of you may know the 2019 G7 Digital Ministry meeting in France. They have a principle of the AI. So G20's agreement. So this is a outline of the OECD AI principles. I don't mention it in details, but principles are inclusive growth, sustainable development, and well-beings were one of it. And the second, people-centered values and equity, and transparency and accountability. Also, robustness, security, and safety, and again, accountability. So they need for predictable, stable, and flexible development and use environment, they said. And therefore, practical guidelines should be needed and based on the human-centered approach. OECD's principle is like this. But it is 2019, it's before generative AI is coming up. So this year, maybe I think this May, so Hiroshima AI process, Prime Minister declared. The main point of ministerial statement as follows: understanding of priority risk, challenges, and opportunities based on the OECD report. So because they also mentioned about the OECD report. And second, formulation of international guidelines and code of conduct for advanced AI systems. Third, project-based cooperation, including promotion of research contributing to countermeasure against disinformation, but mostly like other countries. So this is a real AI situation in Japan, I think. So this newspaper, this picture is the day before, October 2nd, the Yomiuri Shimbun newspaper I just found. So in government, it seems that they want to publish their presence in AI field, but in reality, there is not much concrete ideas, I think. So rather, they seem to be encouraging the private sector to expect their opinion. Sometime Google, Facebook, or the AI producers, they are invite and make a speech. But young people, sometimes my children, especially university students, seem to be using AI almost without hesitation. So this morning, Edmund said they don't so much care about personal data or something like that. So we often see commercials, especially in TV, by software development companies that claim to use AI to improve work effectively, so they can shorten the time and cost cut something. So however, the actual use of AI in companies does not seem to have progressed that much. But local government, I think they have a lack of the capacity, and so sometimes they are using, they permit their officers to use the AI now. And in fact, many companies are afraid to use AI and prohibit its use, especially the software company. Big companies almost, I think, they don't want to do that. Sorry. So it's my opinion on behalf of myself, so to speak. It's like opening the Pandora's box. Maybe the internet was one of the Pandora's box. I think this is the second one, I think. So this is not AI, but in the UK, maybe 10 years or like that, the name and the names and the birthdays of almost all citizens of England have been leaked. So the birthday cannot no longer be used to identify individuals. So they cannot use even now. And it is not good to be to risk conscious, but given that in that case of AI, the developers themselves, probably as you know, have said that regulation is necessary. Something like the OECD principles is needed in the Indo-Pacific areas too. So also this is my opinion, and I believe that the too much regulation will simply create a chilling effect in many fields. As the saying goes, fear is groundless. Fear alone will not get anything done. However, the biggest problem with generative AI is that we do not know what will come out of it. So it is necessary to put certain curves on it now. One of the things that can be done now is to require the disclosure of information on what is actually happening with the products of generative AI. Strongly, I feel. Thorough disclosure of information may help to avoid tragedies. So such a kind of, she mentioned. As ISP's point of view, I'm really afraid of the battle between AI to AI. It will make a huge traffic over the internet. That's it. Thank you very much.
Thank you very much, Toshi. It's really great that you were able to provide some of your recommendations at the end. And I think that this is where we really want to focus some of our discussion towards the end, because it seems that in Japan, there is some political will and desire to regulate AI, yet at the same time, there's always a countervailing force about wanting to support innovation in this area, and it seems that quite a lot of it is being left on the shoulders of industries and individuals. Maybe we can actually talk about, since you mentioned you're a professor, and Derek is also a lecturer too at university, how do you approach your students when your students want to use ChatGPT? Well, we can ask that question later, but first let's move to Derek. Taiwan's neighbor to the south, the Philippines. Derek, you've just recently done some research and interviewed policymakers in the Philippines on this and related areas. So we'd love to hear some of the latest information and feel the pulse on what's happening with AI regulation in the Philippines.
All right. I'd like to thank the organizers for inviting me on this timely panel, and of course to our moderator, Seth, for reaching out to our group for insights from the Philippine side. So, good afternoon to everyone. I have the remarkable opportunity to present and introduce to you all the work that we have been doing through a research partnership between the Ateneo de Manila University, a private university based in the Philippines, and the Peace Research Institute Oslo, or PRIO, a non-profit research organization based in Norway. I'm here in my personal capacity. Any opinions, insights extrapolated from these findings are my own and mustn't be construed as official policies, positions of the organizations involved in that of the Philippine government. So I've been given 10 to 15 minutes. I'll do my best to fit it within that time frame, right? Okay. Okay, so I'll be sharing a bit on the project that we are doing, and I'll be discussing the framework that we at Ateneo and PRIO are using. And in a short while, I'll be sharing the preliminary findings of the study that we are doing with due reference to some policy implications for the case of the Philippines and those interested in understanding the digital transformation dynamics that's taking place in the archipelago. So the work that we're doing is a multi-year project that began last year, set to end sometime in 2025. We recently concluded on-site field work through a series of key informant interviews and the culminating focus group discussion with industry stakeholders from the private sector, government, and academia just last week, actually. The Philippines case study is one of 3 being developed right now. Other case studies are being prepared in Indonesia and Malaysia by the CSIS Indonesia and the University of Kuala Lumpur, respectively, also in partnership with PRIO. And we are set to officially release the findings in a policy output and a report in the first to second quarter next year through the PRIO website. So please be on the lookout for that. The NORM project, as now we fondly call it, is very much an enterprise at looking at the norm building dynamics between China, the communist government in Beijing, and Southeast Asia, in the case of my presentation with the Philippines. And we look at how this norm building dynamic spills over in various aspects of the Philippines' digital transformation, such as digital and technological norms, ethical norms and regulations surrounding the use of 4IR, Fourth Industrial Revolution technologies, and the broader geopolitical and geoeconomic contestations in the Philippines' digital and cyber domain. So we wanted to pursue China-Philippines digital cyber norm building dynamics along critical lines of inquiries, namely how extensive is this dynamic happening, if it ever exists, what areas of cooperation in the digital domain exist between the 2 countries, if there are any, how did the Philippines receive the influx of technologies from major powers, and to what extent does perception feed into the Philippines norm building dynamics with Beijing, and explore what makes it unique and what the limitations and opportunities are. So the preliminary findings. We found out, well, we point to the fact that there exists no observable norm building dynamic between China and the Philippines, at least due in part to the Philippines' broader lack of discussions surrounding the importance of 4IR technology, like AI, in everyday lives. Now, both houses of the Philippine Congress is startled by the explosion of 4IR technologies in daily lives and have forwarded resolutions in aid of legislations, not yet law, that regulate AI in efforts to protect certain sectors such as BPOs and OEMs from outright automation, protect the public against AI-powered image generators like deepfakes, preserving labor and working standards, and protecting the manual labor workforce against digital sweatshops. Admittedly, we also found how discussions surrounding 4IR and relevant technologies with daily commercial use are not as advanced or forward-thinking compared to other neighboring countries in Southeast Asia. Take, for example, how the Philippines is deemed the social media capital of the world, boasting significant hours online or on social media. But when news broke out about the Cambridge Analytica in 2018, not much fuss transpired in the Philippines, it would be a good year later, in 2019, that people started paying attention to the issue, realizing that the wider implications of big data that is easily accessible by politicians with grand ambitions. Under the present administration of Marcos Jr., digitalization really places high in the agenda, but whether or not it is the top priority remains an open debate. There are some institutional reasons why that is the case. For example, our Department of Information and Communications Technology, mainly responsible for developing a national ICT strategy, by the way, is a relatively nascent organization and was only set up in 2016 to 2017 under the previous Duterte administration. Our National Privacy Commission, which had been around since 2014, remains laggard in terms of budget appropriation and could not effectively enforce our national privacy law, which at the time served as a stellar example for the rest of ASEAN, who are now also in the process of setting up their data privacy legislations. Ever since the pandemic and following the recent effort of the Philippine government to enact, for example, the SIM registration measures, text and call scams have been happening year-round. I myself receive them on a daily basis. Another would be fundings for research and development took a back seat for many years, and the Philippines is now only catching up with the rest of the world. We do not have important discussions on quintessential line items such as data sovereignty, even regulations themselves, right? And impact of tech on sectors and workforce. The government and other stakeholders are still very much siloed, and ideas haven't really gone past their echo chambers. And policymakers on the ground haven't advanced meaningful discussions for fear of terminologies being too complex for the ordinary Filipino. And of course, lastly, the Philippines is still mostly dabbles with basic concerns. Basic digital norms debates in the Philippines have not really moved past the shadow of national privacy concerns. The government is fixated on erecting infrastructure that is part and parcel to the discussion of technological advancements. The Philippine government is still dealing with cross-archipelagic internet connectivity because there are really remote places in the more than 7,000 plus islands of the Philippines that really do not have access to basic internet. Our government is so fixated on providing IDs, for example, that we have so many government IDs, one for driving, one for national health insurance, one for tax, so on and so forth. So the efforts to centralize this have only begun in mid-2010s. Even discussions of cloud-based services haven't really sunk in and haven't really taken off so soon within government that the government still prefers having physical servers on the ground to show quote-unquote infrastructure. We also conducted 2 FGDs in one day, actually. One with the commercial, legal, and academic experts, and the other with the defense establishment. Actually, our FGDs only serve to confirm many of the insights raised and shared in the interviews. There is admittedly great challenge and even pressure within the government to push regulation of AI, mainly because according to one interviewee, the Philippines can only take reactive stance to disruptive developments. The regulations forwarded in both houses of Congress have yet to specifically identify what aspects of AI should be regulated, and regulations in other aspects of the digital either remain non-existent or still too siloed. Another insight we extrapolated was that the Philippine political economy is a very big determinant of the Philippines' digitalization trajectory, and that there are inherent interplay with major powers, imprints in the digital competition within the Philippines. For example, the Philippines still grapples with tech duopoly in the telecom sector. Both service providers host Chinese technology, both hardware and software. A third China-backed alternative telco was set up in 2016. Another notable instance was that Filipinos just genuinely prefer cheaper technology options and will choose whichever brand fits the bill. It just so happens that Chinese technologies can provide cheaper prices compared to Western brands. And, this really appeals to Filipino sensibilities on, getting the cheaper option. Western brands like Ericsson and BlackBerry have previously penetrated and have been flourishing in the Philippine market before. But the entrance of Chinese brands have really disrupted and upended the game in the Philippines. The national government, local government dynamics also does not help, as jurisdictional contestation and shifts in budget appropriation happens based on personalities or politicians' personal preferences. This, in the long run, stifles synergies in implementing meaningful tech reform that spans all the provinces. The Philippines to date is doing its best to diversify its technological portfolio outside of conventional service providers such as China. The Philippines always espouses on developing cooperative measures with countries it shares its values with, including Taiwan, actually. Okay, so the broader policy implications of the findings that we unearthed points to the inevitable trajectory of regulating 4IR technologies, including AI. For the case of the Philippines, it's not really a matter of when. There are now bills actually precisely aimed at regulating AI. It is more a matter of what form and shape these regulations will take and how these will be implemented later on. We also found that there is a need to bring industry stakeholders out of their echo chambers and compel them all to talk with one another. The important insights will come from these experts, and the broader public awareness on 4IR needs to be promoted. Not many are aware that AI is now here in the Philippines, and some still think that the technology is a few years away. But for us, it is here. AI is here, present in businesses, even in academies, and it is here to stay. The Philippines' preference for the cheapest option is noteworthy, not just for businesses who want to enter, but also plays into the larger US-China digital strategic competition within the Philippines. The question now then is, from whom will come the next cheap alternative, tech alternative be? Because at this rate, China is winning. And of course, I would like to echo my fellow panelists who went before me. Yes, this is pretty much like Pandora's box. One participant from our FGD raised an interesting point on the Philippines' digital transformation. And I quote, the Philippines' digital transformation leapfrogged during the pandemic, but its cybersecurity did not. And of course, this already tells you a lot about the situation and circumstance that we find ourselves in. I'll end my presentation here. Thank you and good afternoon.
Thank you very much, Derek. It's great that you were able to put the discussion not only within the larger geopolitics in the region, which of course is one of the themes of the TWIGF this year, but also to put it into context within the Philippines 4IR, so the rest of the technology discussions. It sounds like in the Philippines, very reactive, still siloed, budgetary concerns. So thank you very much for giving us the latest information. Let's turn to our panelists now who are joining us online. I'd like to introduce Mr. Jared Ragland. So we're shifting gears. Jared is coming to us from Singapore, so still in Southeast Asia today. Jared serves as the Senior Director of Policy, APAC, at the Business Software Alliance, BSA. Working with members there, he develops the international strategies to work on markets and promote innovation and digital trade throughout the region: Australia, China, India, Indonesia, Japan, Korea, Singapore, Thailand, and Vietnam. Jared used to work for the United States Patent and Trademark Office's Intellectual Property Rights Attaché in Shanghai, and before that, with the United States Trade Representative. So great to have you, Jared. Please share with us your views from the BSA. Thank you.
All right, let me see if I can share my screen. And hopefully that is showing what it is supposed to show. All right, well, thank you, Seth. Seth and I go way back to those days when I was in the US government, and it's nice to be on this panel with you, Seth, and with all the other esteemed panelists. I'm going to try to make up a little bit of time here, so I might skip over a few of these slides, but some of what I was prepared to talk about has already been touched on anyway, so that's great. Jared Ragland, based in Singapore, looking out after the Asia-Pacific region. Let me make sure I know how to click here. Okay. So BSA, the Software Alliance, just a quick introduction of the organization. We're a global industry association. We represent cutting-edge enterprise software companies, companies that offer software-enabled solutions to business customers primarily. So we're not representing the consumer-facing tech industry like social media and e-commerce, but our companies are providing services to organizations like universities, government agencies, and other businesses. These companies are at the cutting edge of all kinds of technologies: cloud computing, customer relationship management, cybersecurity, and of course, artificial intelligence and data analytics. So that said, I want to emphasize that the issues around AI and many of the issues that we deal with, they go way beyond what's considered a traditional technology industry. The benefits and the uses of AI range in essentially every sector of the economy. It's essential in transportation sector with helping, for example, airlines manage routes, detect maintenance requirements in advance, manage refueling and reloading more efficiently. And the same essentially can be said for every other sector: manufacturing, supply chain, agriculture, you name it. So the stakes are really high. The technology is really, really important, especially in the enterprise space. And so that's why we are all talking about it. I should emphasize that, we have been activated, many of us, not necessarily us here at BSA, but, many people across the world have been activated by generative AI, which is an important new development and is raising a lot of interesting questions and concerns. But artificial intelligence, machine learning, it's a much, much bigger and broader set of technologies than just generative AI, large language models. So over the years, BSA, we've been working on this for at least half a decade and more, back to when my colleague from Japan was talking about, 2016 and before. We've put together an enormous amount of resources over the years, and given the intense interest in this subject, we've revamped our AI Resource Center. So if you want to take a look at ai.bsa.org, you can see all kinds of submissions and white papers and policy recommendations. But at the end of the day, it probably all boils down to essentially 5 pillars for responsible AI that we're advocating for. So first of all, we need to build confidence and trust in AI systems. That's really incumbent on the industry, from the design phase to the development to the deployment to the training to the end of life cycle. All of these things need to be built in so that customers have a sense that this technology is reliable, secure, builds in consumer protections and so on and so forth. But we also need help from the government to establish sound data policies. And this means ensuring that policies that are designed to address potential concerns or risks or harms from AI are narrowly scoped to those high-risk use cases and applied to the appropriate entities. And I just want to make a plug for what we call the developer-deployer distinction. Developers of AI have a lot of influence in how AI technologies are developed and designed, but they have very little control over how it is used and by whom. Deployers, on the other hand, may not have as much influence in how the AI technology actually works, but they're in a much better position to tailor those solutions to their customers and be in a position to respond to customer concerns. We also need effective cybersecurity and privacy protection, not just for AI, but across the board, as the previous panelist mentioned. But we have to make sure that those policies are designed to achieve those goals, and they don't encumber technologies like AI with unnecessary requirements. For example, data localization requirements or restrictions on international data transfers are usually unhelpful for both cybersecurity and privacy protections, and they're certainly unhelpful for driving AI-related innovation. Obviously, the governments have a role to play in partnering with industry to promote research and development, and last but not least, reskilling existing workforces that may need to be upskilled or reskilled in a changing economic environment, as well as bringing up the pipeline of new talent. And by the way, not every person who's going to work in an AI environment needs to be a computer scientist. There's going to be a lot of interesting issues coming up, including the need for anthropologists and sociologists and all kinds of stuff when it comes to ethical AI. What I was really asked to do, though, is touch on some regional policy developments in the Indo-Pacific, and so I wanted to do that. So I was going to start with Japan, but I probably will skip over most of that because I think we already got a pretty good sense of what's going on in Japan from our previous panelists. I will indicate that they tend to be focusing mostly on upgrading risk-based voluntary guidance at this stage. There's been some talk about legislation, but they don't seem to be taking a super hasty approach to that. There's a lot going on domestically. Japan is really a leader in thinking about responsible AI and how to implement that at a domestic level without necessarily coming in with heavy-handed, legally binding approaches. And as the previous panelist mentioned, they have been a leader in international discussions around AI for many years, including this year during their G7 host year to come up with the consensus at the G7 around the Hiroshima AI Action Plan. Singapore is another market that has been very active for a long, long time in the AI space, including international leadership. In 2019, they announced their Model AI Governance Framework at the World Economic Forum. They have established a national artificial intelligence strategy. In 2021, Singapore joined Japan and the European Union in amending the Copyright Act to include what we call a computational data analysis exception that helps to protect entities from unwarranted copyright liability when using automated means to collect publicly available information to train AI systems. More recently, Singapore's Personal Data Protection Commission has issued advisory guidelines around the use of personal data within AI. And finally, I want to mention that they've announced they formed a AI Verify Foundation, which includes companies and other stakeholders in partnership with the Infocom Media Development Authority to develop AI testing tools to help enterprises, including maybe even especially small businesses, to use AI in an ethical and responsible manner. Just a quick survey of a few other major markets that we've been following, and this is by no means comprehensive, but Australia is also exploring this area with a lot of interest. They recently published a discussion paper on supporting responsible AI, and we're now waiting for their response to a substantial amount of stakeholder input during that consultative period. If you're interested, you can go to our website and look under the policy tab and find our submission along with everything else we've submitted. So we definitely took a position on that. They also have an AI task force to review the use of AI in government agencies, which I think has been raised at least a couple times on the panel already. I think this is really important. This is the kind of technology that you may want to channel, but you're not going to stop. And so you might as well figure out how to harness it in a way that's safe, effective, and productive. I want to flag China's interim administrative measures on generative AI. So the PRC issued these rules in draft form earlier and then issued them in final form later this year. And I want to note that even the PRC took a step back from some of the more prescriptive requirements that were described in the initial draft for consultation. And based on a substantial amount of industry feedback, and other stakeholder feedback, their final rules are a bit less prescriptive. Now, I would say that there's still a lot in those rules that if interpreted very strictly and enforced aggressively, could have a fairly stifling effect on AI development in China. But clearly, the government there was looking at that, looking at these measures with an eye on not only controlling or regulating the space, but also maintaining competitiveness, of which China, of course, is very competitive in the AI space. India has been very active for many years. I remember a few years ago talking to their NITI Aayog, which is essentially a quasi-government agency think tank set up to promote transforming India. It's the National Institute for Transforming India, I think is what NITI stands for. Anyway, they've put out back in 2000 a document around enforcing mechanisms for responsible AI. More recently, a lot of the talk has shifted to India's Digital India Act, which will be a whole-scale revision of their Information Technology Act, first promulgated 23 years ago in 2000. But that's on an uncertain path for enactment. It could take a while. More recently, they passed their Digital Personal Data Protection Act, which in many ways was a really welcome and long-awaited development. However, it's our concern that some of the more strict approach to data usage, we call these grounds for processing, much more restrictive than, for example, the EU General Data Protection Regulations, the GDPR, and much more consent focused. These could have potentially fairly substantial negative impacts on the ability to develop AI in India. So we'll look carefully with the implementing guidelines as they come out on that. Korea is one of the Korea's been studying this issue for many years also. It's one of the only countries in the region I'm aware of that actually has draft legislation before the parliament. I could be missing a few, but their National Assembly is actively looking at draft AI legislation right now. It's mostly focused on figuring out how to harness and promote AI in Korea, but like pretty much any piece of legislation that we look at in any market, we are looking at it with a concern about how well it will interact and interoperate with emerging international practices. Thailand is also looking at some draft AI legislation. We've bit more concerned about that legislation if it moved forward as currently drafted, given that it gives the government pretty substantial powers to create standards, both technical standards and maybe standard contractual arrangements that, from what we can tell, would not really be aligned with what we see as emerging international practice. So hopefully we can continue to have conversations with the Electronic Transactions Development Agency, which is developing those rules. So that's a little bit of a tour of the Asia-Pacific region as I see it from my seat here in Singapore. Just a really quick summary of some of the trends. As a general rule, out here in Asia-Pacific, most governments have been focusing on voluntary guidelines and not moving quickly to legally binding rules. I think that's probably wise given how quickly things are moving. We need public-private consultations on these guidelines and these rules. And they are looking at figuring out how to combine their interest in maintaining or enhancing their technology competitiveness while mitigating risks to consumers and other challenges. The main concerns I see are countries that are beginning to move fairly quickly have not done the thorough stock take that the European Union and others did on how existing laws already address some of these perceived risks and concerns. And it's a challenge, but we need governments to be talking to one another so that at the end of the day, we're moving towards an internationally interoperable set of regulations if we want to really be able to both mitigate the risks and harness this technology for all of the positive potential that it has. So I'll stop there and turn it back over to you, Seth.
Thank you very much, Jared. I think that's a really great example of the state of play in many different countries in the Asia-Pacific region. And I really enjoyed that you raised some of the definitional issues here from your stakeholders between developers, deployers, and of course, even though generative AI has caught everybody's attention because it goes direct to consumers, of course, that your industry has been looking at these issues for many, many years in different kinds of contexts. So thank you very much for sharing the website. You can look at some of the BSA submissions on these issues over the years. That's great. I'd like to turn our attention now to Oceania. In New Zealand, we have Lionel Tuffery Huria. She's managing partner of Kahui Law. Over 30 years, Lionel has specialized in intellectual property, and she's worked for a diverse range of clients across the globe. She's regarded as one of New Zealand's leading experts on indigenous intellectual property law in New Zealand and the Pacific. She specifically advises Maori organizations on IP issues and is passionate about helping Maori navigate the IP system. So I've worked with Lionel a number of years on indigenous rights in the intellectual property area. But of course, when we're talking about AI regulations and innovation, these are very issue adjacent. So we'd love to hear from Lionel about what's happening in New Zealand and from the perspective of indigenous rights. Lionel?
Kia ora, Seth. O te rā, kia ora koutou katoa. Yeah, my name is Lionel Tuffery Huria. I'm delighted to be here, so thank you for having me. And I know we're running out of time, so I'll just get straight in and share my slides, and hopefully they turn up all right. Is that working okay? I can't see my slides. Sorry, I seem to have lost them. Here we go. I hope that's working okay. Please let me know if I don't change pages. So I'm going to talk about Indigenous data sovereignty and Indigenous data governance, and in particular, and then also have a quick look at the algorithm charter that's been set up in or is in force, and not in force, but is in play in New Zealand. And these issues are quite complex because what we have seen over the years is Indigenous data has been used to tell a particular narrative about Indigenous people, and it's not a good one. And so there is a desire for that narrative to change, and to enable that, we need Indigenous people to have some control over Indigenous data, have some rights of Indigenous data sovereignty, and also be involved in the governance of their own data. So what am I talking about when I talk about Indigenous data and Indigenous data sovereignty? Did that change slides? I just want to double check. Kia ora, thank you. So what is Indigenous data? It really is, as you all know, data, information and knowledge, including Indigenous knowledge, that we consider as digital or digitizable. It is about, from, or connected to Indigenous peoples, their languages, their cultures, their resources, and their environments. So just about anything to do with Indigenous peoples and anything they are connected with, which is quite large, but also if you think about all the knowledge, also, you know, kind of segregated out at the same time. So Indigenous data sovereignty, this is the idea that Indigenous people have inherent rights and interests in their Indigenous data, that Indigenous, not just in their individual data, but also in collective data, because like I said, we have particular narratives that are told about Indigenous peoples and Indigenous peoples as a group to tell a particular narrative about Indigenous peoples. And so having control of that collective data is also really critical for Indigenous peoples. And those inherent rights and interests include the collection, the ownership, and the application of Indigenous data. So having control of how that information is collected, how it is owned, and then how it is used and how it is applied, and how we can, again, like I said, tell a different narrative in relation to Indigenous peoples. And if we have a look at the Indigenous, so the United Nations Declaration on the Rights of Indigenous Peoples, it talks about Indigenous communities having the right to have data, both primary and aggregated, returned to them for their own use, noting the importance of the confidentiality of that data, particularly as it applies to individuals who have participated in the data collection exercise. So this is not a just a New Zealand idea. This is actually an idea that's been, or a recommendation that's come out of the UN. So what do I mean about Indigenous data governance? And so how do we implement processes, practices, standards, and policies that enable people to have control over Indigenous data and to achieve the aspirations of the United Nations Declaration on the Rights of Indigenous Peoples, but also achieve the aspirations and support Indigenous peoples to achieve what they need to achieve in relation to their own data. So in New Zealand, this year, Te Kahui Raronga, which is a collective, a data collective that was established by the Māori iwi Leaders Group to look at the issues of data, and they've actually designed a Māori data governance model, Māori being the Indigenous people of New Zealand. And this governance model is available on their website for you to access. And I'll just quickly run through some of the key elements that they've put together for this governance model. The vision is tuia te korowai o hene raronga. Data is for self-determination. And what that vision really means is that it is all about enabling Māori, both families or whānau, iwi, which is tribes, and then hapu, which is sub-tribes or kinship groups, and Māori organisations, businesses and communities to pursue their own goals for cultural, social, economic and environmental well-being, and to do that, to use data to help support those aspirations. So the data governance model establishes these 5 values. It talks about nurturing data as a taonga, nurturing data as a treasure, taonga meaning treasure in the Māori language. And what they mean by that is that if something is a treasure or something that's very precious to you, then you will actively protect that taonga, that treasure. And so it's it requires both the Crown or the government and Māori to be actively protecting data because it is precious, it is a taonga, it is a treasure. Another value is that data will always be used for good. As I mentioned probably several times now, data has been used to tell particular narratives about Indigenous peoples for years, for decades, for centuries. We need to switch that narrative. We need to start telling the stories from an Indigenous perspective. We need to, another value is to put iwi data in iwi Māori hands or in Māori hands, and so that they can keep that data safe, keep their people safe. It means implementing a number of processes to ensure that this does happen. It's all about being accountable. So data is relational. All data comes from somewhere or someone. And with those relationships comes responsibilities and accountabilities. Agencies and organisations that hold Indigenous data must be willing to be held to account and to be answerable for their decisions that they make and the actions that they take in relation to Indigenous data. We also need to think about decolonising the data systems, and this requires the cessation of practices that exploit and extract from Indigenous land, life and knowledges. The colonisation process has taken lands, it has taken artworks and cultural works and languages away from Indigenous peoples. You know, data has the capacity to do the same thing. So we need to decolonise the data structures, the data ecosystems, because these continue to perpetuate the dispossession of Māori and Māori data while shifting the locus of control back over to Māori, back into Indigenous control. So those are the values that underpin the model. And then lastly, these things called data po, or po meaning stakes or stakes in the ground or or poles that hold up the roof and keep you safe and secure. So there's eight PO that are set out in this governance model. The first one is data capacities and workforce development. So investing in workforce development for Indigenous peoples is critical to ensure that we can achieve those aspirations for Indigenous peoples. We need to have a data infrastructure because that's essential for delivering on those outcomes for Indigenous peoples. It needs to be flexible, it needs to be scalable, and it needs to be interoperable and offer technology options that power choices close to where decisions are made. We need to have, there needs to be data collection, but that also needs to be underpinned by those principles and values that I talked about before. So traditionally, data collection has always been done in an extractive, very focused on agency agendas or entity agendas. And so therefore there's really limited benefits that are achieved from the use of that data. It's important to ensure that that collection is turned around and we actually look to achieve, use data for good, as I mentioned earlier. Data protection, we need to ensure that data is kept private and confidential, and in particular, sensitive information stays sensitive and stays confidential. Data access, sharing and repatriation. So we need to ensure that there is good access, access to data that is not necessarily available, and in the situation I'm talking about, access to data that's held by governmental organisations who don't share that data, and then also repatriating data where it is appropriate to do so, and ensuring that it is returned back to Indigenous peoples. Ensuring that data use and reuse is consistent with the values that we've talked about, obtaining consent where it's appropriate to gain consent, including not just consent from individuals, but also consent from collectives, and ensuring we're linking those two, and ensuring that we're getting the consent from those two parties because they're quite different and they have quite different interests in relation to Indigenous data. We need to ensure that the data quality is of a high standard, and its integrity is maintained at all times. And we also need to be careful about how we classify data. This classification, the classification that we see at the moment, again, just automatically leads to certain narratives, and they're driven in that way. And so therefore, being careful about how we classify so that we get different outcomes for different reasons. And so in New Zealand, we have the Algorithm Charter for Aotearoa New Zealand. It's a charter that's, its main aim is, it's a commitment to ensuring that New Zealanders have confidence in how the government agencies use algorithms within the government agencies. It was released in July 2020. It has been reviewed since then. It's supposed to be reviewed every 12 months. I couldn't quite find if it has actually been reviewed every 12 months since then, but I have been informed it has been reviewed. It's important to know that this charter is specifically not designed to address the issues around Māori data sovereignty, and as you can probably guess, that means I don't think it's adequate, but we'll get to that outcome at the end. Sorry, I've got the same slides, some same points here. There are currently 29 signatories that different government agencies and entities have signed up to this charter in Aotearoa, New Zealand. So what is the charter about? The commitments that are set out in this charter, it talks about maintaining transparency by clearly explaining how decisions are informed by algorithms, what algorithms are used, and how they inform those decisions for government agencies, ensuring that there's plain English documentation around the algorithms, making the information about the data and processes available, and publishing information about how data is collected, secured, and stored. Ensuring that there's a clear partnership, delivering clear public benefit through acknowledging the Treaty of Waitangi, which is one of the founding documents of Aotearoa New Zealand. It was signed between Māori and the English when to enable New Zealand to be settled. So embedding that Te Ao Māori perspective, ensuring that there's a focus on people, that there's been active engagement with people, communities and groups, making sure data is fit for purpose by understanding its limitations and identifying and managing biases, that there are privacy, ethics and human rights are safeguarded through the use of these algorithms, and then making sure that there's human oversight of these algorithms as they are used within the government agencies. So New Zealand's made some progress in monitoring AI, and it's good progress, but it still falls short of Indigenous aspirations for data sovereignty and data governance in Aotearoa New Zealand. That's the end of my slideshow. I'll hand back to you, Seth. Kia ora koutou.
Thank you very much, Lionel. It's really great to hear the perspective from a values-based approach here. And certainly shifting the narrative is important with respect to the notion of data sovereignty for Indigenous peoples. And I really love the concept of data as taonga. So thank you very much for sharing that with us today. I recognize that we are out of time, but I would, of course, welcome any burning questions to come up to the panel afterwards. That's absolutely okay with all of us, or feel free to continue to stay in touch with us. Today, we were able to really go make a whirlwind tour across the region on what's happening with artificial intelligence regulations, how different countries are approaching this, the different kinds of angles and approaches that policymakers are taking on this around the region. So I think we all agree that it's something to continue to watch because nothing is final at this point. In fact, we're really just at the beginning. So I'd like to thank very much all of our panelists here today in the room as well as online. So thank you very much.